Lesson: Impact of climate change on contracting obligations. The impact of climate change on contracting obligations has become a pivotal issue in contract law, reflecting the urgency of addressing environmental challenges within legal frameworks. Climate change introduces unique risks and uncertainties into contracts, affecting performance, pricing, and even the feasibility of fulfilling contractual obligations. Professionals in the field must be adept at navigating these complexities to mitigate potential disputes and adapt to evolving legal landscapes. This lesson explores actionable insights and practical tools that can be employed to address the impact of climate change on contracting obligations, providing a roadmap for enhancing proficiency in this emerging area of contract law. One of the primary ways climate change affects contracting obligations is through force majeure clauses. Traditionally, these clauses excuse non-performance due to unforeseen events beyond a party's control, such as natural disasters. However, the increasing frequency and intensity of climate-related events challenge this notion of unforeseeability. Legal practitioners must now consider whether climate change-induced events fall under force majeure and how to draft clauses that adequately reflect current and future risks. A practical tool for addressing this challenge is the inclusion of specific language in contracts that explicitly identifies climate-related events as part of the force majeure provision. This approach not only clarifies the parties' intentions, but also reduces ambiguity in potential disputes. The unpredictability of climate change necessitates a proactive approach to risk allocation. Contracts must be structured to account for potential disruptions, such as supply chain interruptions or resource shortages, which could affect parties' abilities to perform. One effective framework for managing these risks is the use of adaptive contracts. These contracts incorporate mechanisms for renegotiation or adjustment in response to changing circumstances. For example, price adjustment clauses based on environmental indices can help balance cost fluctuations resulting from climate impacts. By building flexibility into contracts, parties can better manage risks and maintain contractual relationships, even in the face of climate-related challenges. Case studies provide valuable insights into how climate change impacts contracting obligations and the strategies employed to address them. Consider the case of a construction project in a coastal region vulnerable to rising sea levels and increased storm activity. The project faced delays and cost overruns due to severe weather events, leading to disputes over contractual responsibilities. The resolution involved revisiting the force majeure clause and implementing a risk-sharing mechanism for climate-related delays. This case highlights the importance of anticipating climate risks and incorporating adaptive strategies into contracts to minimize disruptions and disputes. Statistics underscore the growing relevance of climate change in contracting. According to a report by the Global Commission on Adaptation, climate-related disasters cost the global economy approximately $520 billion annually and push 26 million people into poverty. These figures emphasize the economic impact of climate change and the necessity for contract law professionals to integrate climate considerations into their practice. By doing so, they not only protect their clients' interests, but also contribute to broader efforts to mitigate climate risks. Another practical tool for addressing the impact of climate change on contracting obligations is the use of sustainability clauses. These clauses commit parties to environmentally responsible practices, such as reducing carbon emissions or utilizing sustainable materials. Incorporating sustainability clauses into contracts not only aligns with corporate social responsibility goals, but also anticipates regulatory changes aimed at combating climate change. For example, a supply contract might include provisions requiring suppliers to adhere to specific environmental standards, thereby reducing the carbon footprint of the supply chain. By embedding sustainability into contracts, parties can enhance their resilience to climate impacts and contribute to a sustainable future. The legal landscape is also evolving in response to climate change, with courts increasingly recognizing the relevance of environmental considerations in contract disputes. This shift is evidenced by cases where courts have interpreted force majeure clauses in light of climate change. In one notable case, a court ruled that a hurricane, exacerbated by climate change, constituted a force majeure event, excusing non performance. This precedent highlights the need for practitioners to stay informed about legal developments and adapt their strategies accordingly. By understanding how courts interpret climate related contractual issues, professionals can better advise their clients and craft robust contracts that withstand legal scrutiny. A step by step application of these insights involves a comprehensive approach to contract drafting and negotiation. First, parties should conduct a thorough risk assessment to identify potential climate related impacts on contractual performance. This assessment should consider factors such as geographic location, industry specific vulnerabilities, and regulatory changes. Next, parties should collaborate to develop adaptive strategies such as force majeure clauses, price adjustment mechanisms, and sustainability commitments. Negotiation should focus on aligning interests and ensuring that both parties understand and accept the allocation of climate-related risks. Finally, contracts should be periodically reviewed and updated to reflect evolving climate conditions and legal precedents. This iterative process ensures that contracts remain relevant and effective in the face of changing environmental and legal landscapes. The impact of climate change on contracting obligations extends beyond individual contracts to influence broader business strategies. Organizations are increasingly integrating climate risk management into their operations, recognizing that resilient contracts are a critical component of overall risk mitigation. A practical framework for aligning contract management with corporate climate strategies is the Task Force on Climate-Related Financial Disclosures recommendations. These recommendations provide a structured approach to assessing and disclosing climate-related risks, encouraging organizations to incorporate these considerations into decision-making processes. By adopting the TCFD framework, businesses can enhance transparency, improve resilience, and strengthen stakeholder trust in their climate strategies. In conclusion, the impact of climate change on contracting obligations presents both challenges and opportunities for contract law professionals. By employing practical tools such as adaptive contracts, sustainability clauses, and risk-sharing mechanisms, practitioners can navigate the complexities of climate-related risks and ensure that contracts remain robust and effective. Case studies and statistics underscore the urgency of integrating climate considerations into contract law, while evolving legal precedents highlight the importance of staying informed about developments in this area. By adopting a proactive and comprehensive approach to contract management, professionals can protect their clients' interests, contribute to climate resilience, and enhance their proficiency in this emerging field.